in a strange street. My family can't pronounce the name of the place correctly. If they told you an asylum seeker died in the AZC, in the room B114, don't panic. Pronounce the name correctly. I lived my life as a refugee, and now I became an asylum seeker. No difference. It's all a matter of names. They call us names. Asylum seekers, refugees, workers, strangers, outsiders, newcomers, and stateless. You can call us stateless, but you can't call us countryless or landless. No one is born without a country or without a land. We didn't come from the outside of space, from Mars or Neptune. We didn't fall down by mistake from the Milky Way. We were born on a land, like plants. We grew up. Like creatures, we survived, eating, sleeping, studying, singing, dancing, having sex, having children. We walk on two just like you. So you can call us whatever you want, but we will remain human being. Thank you.
Thank you so much, Aisling, for that very moving introduction. Can you all see me? I'm barely visible above the podium here. Welcome, everyone, to this 5th Grand Challenge panel, which is all about statelessness in mixed migration contexts. My name is Beth Fernandez. I represent the Sigrid Rising Trust, and we're really proud to be a supporter of the Institute on Statelessness and Inclusion. So the word that I think comes to mind on these themes is complexity. So both in the way that migration and statelessness interact, but also, just as the last reading showed, none of us are one thing, and stateless people are also trafficking victims, they're migrants, they're refugees, they're unaccompanied minors. We have a wonderful panel of 5 speakers here today, all of whom are grappling with this complexity in their respective institutions. So we're going to hear all of them, and then we should still have plenty of time for your questions and for discussion. So I'm going to begin by introducing the first speaker. She is Michelle Foster, professor at Peter McMullen Centre on Statelessness at Melbourne Law School. I'm sure known to many of you. She is going to talk about her recently published book, co-authored with Elaine Lambert, which looks at the protection of stateless people in refugee law. Michelle, please.
Well, thank you so much, Beth, and good morning, everyone. I've got the same dilemma of I'm only just being visible above the podium, but I hope you can all see me. So, as Beth mentioned, in today's talk, I'm going to be presenting research that I undertook with my wonderful colleague, Professor Helene Lambert. Unfortunately, she wasn't able to be here, but I acknowledge the work that we did together. It was also mentioned that I'm actually presenting a book, and I should tell you that we worked on this book together for around 4 years. So in light of that and the fact that I have about 15 minutes to try to compress all of that, I'm going to cut to the chase and tell you the punchline, which is that in short, we argue for a better and more effective use of refugee law as one tool for protecting stateless persons on the move. Now, while we all understand that most stateless people do not leave their countries of origin, it's also increasingly recognised that a significant number are forced to do so. And accordingly, the New York Declaration for Refugees and Migrants and the Global Compact on Refugees both recognise that statelessness can be both a cause and consequence of refugee movements. So our argument is that not that the 1951 Refugee Convention will protect all stateless persons on the move, but rather that it's an important complement to the 1954 Convention on the Status of Stateless Persons, which is, of course, the core source of protection for stateless persons in international law. I think in light of this argument, I need to raise the question, or to sort of deal with the question that some of you may already be asking yourselves, is, well, why refugee law? Given that I've just mentioned that there is the 1954 Convention, why is it necessary to think about the Refugee Convention? And I think there are several reasons, which are a mix of pragmatism and principle. So first, while the 1954 Convention, as I said, remains integral part of protecting stateless persons on the move. As most of you would know, it still has less than 2/3 of the number of ratifications of those of the 51 convention, so 91 versus 147 state parties. But I think even more importantly, even of those 91 state parties, only a very small minority have established statelessness determination procedures. And so what that means is, in practice, for many stateless refugees, the only option for protection, the only viable source of protection in a country to which they have fled is in fact a refugee process. Now, of course, we need to still keep advocating, absolutely, for a greater ratification of the 54 Convention and of course for a better implementation of the 54 Convention. And I'm pleased that my colleague Hervé will be discussing that very issue shortly. But in the meantime, and in addition, it's important to also consider refugee protection. Second, while the terms of the 51 and 54 conventions are almost identical, and that makes perfect sense when we consider the history. So I'm not sure if everyone's aware, but initially the convention that was being drafted in the late 40s was supposed to be about stateless persons, with refugees being a subset of stateless persons. But in the end, the two issues were separated, although the protocol on stateless persons was initially a protocol to the 51 convention. As I say, they initially, as you all know, became separated. But once we understand that history, we understand why they're almost identical. However, there are really two important limitations in the 54 Convention. So they're missing two important rights for refugees. One is non-penalisation for unauthorised entry, and the other, of course, is non-refoulement. So it's absolutely important then that where a stateless person meets both the definition of a refugee and a stateless person, that they attain the greater level of protection that's afforded by the 51 Convention. The third reason is that the Refugee Convention has always envisaged the protection of those both with and without a nationality, whether at risk of persecution. Yet there's been very little engagement historically by academics, by scholars, and even through soft law instruments such as the UNHCR guidelines on international protection as to how stateless people may be protected by the Refugee Convention. Our argument is that the capacity of the 51 Refugee Convention has expanded as international law has evolved, and in particular as international human rights law has increasingly constrained state discretion in both the determination of nationality laws and the treatment of non-citizens. As Radhika reminded us yesterday in the plenary opening session, human rights law as we know it postdates both the 51 and 54 Convention. However, it's orthodox in refugee determination that we take into account developments in international human rights law. In other words, the 51 Convention is a living instrument and therefore must be interpreted in light of evolutions of international human rights law that have occurred post-51. And so once we take that into account, I think there's much greater potential for the protection of stateless persons than would have been envisaged in 1951. So, our project, in short, this research involved analysing cases in which a stateless applicant claimed refugee status in a range of jurisdictions, including Australia, Belgium, Canada, France, Germany, Ireland, New Zealand, the United Kingdom and the United States. And we found, to our, I have to say, surprise, literally thousands of decisions that are reached both the tribunal and court level in which stateless persons had sought refugee status. And some of those dated back decades, indicating that invoking refugee status as a source of protection is neither a new nor novel phenomenon for stateless applicants. However, we found that our view that refugee law has this great potential, that it still is not fully realised due to a range of factors, including a lack of clear guidelines for determining statelessness in the context of refugee determination, a lack of knowledge and understanding of statelessness, including the causes and significance of statelessness, and a failure in some cases to incorporate modern human rights standards into refugee law in these cases. On the other hand, there were many positive cases that represent a more contemporary and inclusive approach and indicate the great potential for refugee law in this area. Now, of course, I don't have time to go into all the various issues that we looked at, but we'll just start very briefly with the definition. And so, as I mentioned, the Refugee Convention has always envisaged the protection of stateless persons, because you can see here in the conveniently italicised section that it refers to not having a nationality. And so clearly it's always been envisaged that those who flee persecution without a nationality can be protected. And if you look at that carefully, a few things might jump out at you. So, for example, there's questions about how do we determine not having a nationality? What does that mean? Is it the same as Article 1 of the 54 Convention? What's a country of former habitual residence? And can you have more than one country of former habitual residence? So immediately we can see a lot of issues being thrown out. And sure enough, in the book we do deal with all of them. But what I want to look at, just in a couple of minutes I have left, is the question of persecution. After all, that is said to be at the heart of the refugee definition. And in particular, I'm not dealing with cases where a stateless person is fleeing the same kinds of human rights violations or persecution of those with a nationality. I want to look at types of persecution that are particular to stateless people. And you'll see here that the first two categories are about the causes of statelessness. So the fact that the individual was denied a nationality in the first place, or having been given a nationality, they were deprived of it or denationalised. The second two are more about the consequences of statelessness. And obviously these are not mutually exclusive. I mean, in many refugee claims, people are raising a variety of issues. I don't have time to sort of draw out some of your thoughts from the audience, but it won't surprise you to know if I asked you to hazard a guess as to which of these categories is most difficult for refugee decision makers, you would probably come back with the denial issue, the denial of nationality, and you'd be right, because that is the category that we found most problematic. That is where refugee decision makers are still stuck in, I would say, 1930s thinking. And what do I mean? Well, not altogether, but in some cases. So what do I mean by that? Well, we're all familiar, of course, sorry, this clicker is a little temperamental. We're all familiar with the classic position in international law around state discretion in terms of nationality matters that dates from the 1930 Hague Convention. But this audience would understand that, of course, we might start there, but we certainly don't finish there. As the Inter-American Court of Human Rights has reminded us, the powers of the state in this area are, of course, circumscribed by their obligations to ensure the full protection of human rights. And you might note, the more observant among you might note that this is in 1984, so this is not a new radical phenomenon. We're very familiar with the fact that state discretion is restricted. And yet, we found many cases where refugee decision makers simply didn't take that into account. And I've given you an example here. I'll flick through the relevant human rights provisions because everyone understands those. We can see here a series of cases that all raised the same issues. They were all from cases where a Badoon was fleeing persecution from Kuwait or claiming that their denial of nationality in Kuwait was persecution. And in these three cases, Australia, Canada, New Zealand, I've got another example from the UK, but that seemed overkill. Obviously all different claims, but they all had been dealt with in the same way, which is essentially to say, even though there was evidence of discrimination, the refugee decision maker is saying, it's not really persecution, it's just a sovereign right of a nation to determine its own citizenship laws. And I think the New Zealand one is probably most worrying, where it's this sense of inevitability or helplessness. Statelessness is a phenomenon as old as the concept of nationality, citing a study from 1948. So this is just sort of bad luck, and, you know, things haven't moved on from 1948. But of course, as we know, we've always understood that discrimination is integral, or certainly a very important component in statelessness, and I think that's been very well highlighted in recent work by the UNHCR that's highlighted the connection between statelessness and minorities, and indeed has been picked up by the UN Special Rapporteur on Minority Issues, who we'll hear from later today, that emphasises that, of course, this is no coincidence. This massive overrepresentation is no coincidence. The denial or deprivation of citizenship is too often the result of deliberate policies and practice that render minorities stateless. Fortunately, I have some positive counterexamples. So we can see in a later New Zealand decision that in exactly the same facts, but a little bit more sophisticated argument that came in that case, so more country of origin evidence, more information about the discrimination that underpinned the nationality laws in that case, and indeed the refugee decision maker was able to say, actually, the statelessness is not just unfortunate, it's not just a coincidence, it's intimately linked to discrimination, and hence refugee status was granted. So look, I don't have time to go into all my other examples, but just briefly I'd say that when a case related to the withdrawal of nationality, so a denial of citizenship, refugee decision makers are much more comfortable. There's something, I think, instinctive about saying, well, you once had something that's been taken away, that seems persecutory, especially when it's linked to, of course, a refugee convention ground. And also, even though sometimes lower level decision makers would fall into the kind of sovereignty trap, it was quickly rectified on appeal. So you see here a case from the US, where the first judge had talked about the country having a sovereign right to essentially withdraw nationality in that case, and the Seventh Circuit quickly quashed that decision, saying, look, that reasoning's problematic, it's arguable that such a program is in fact a particularly acute form of persecution, and they talk about historical examples. So many more positive examples in that context. How am I going for time? Oh, great. One of the issues that's come up as well is even once for a refugee applicant, even if they can establish that the denial or the deprivation constitutes persecution, or at least is a violation of international law, sometimes the question is, well, is it serious enough to be persecution? And I think for members, everyone at this conference would find that a shocking question because it sort of seems self-evident that that's the case. And what we found was that very few decision makers really grapple with that because in most cases, as I mentioned, a refugee claim is not just about the denial of nationality, it's about all the consequential human rights violations that flow from that. But we did, however, find a couple of really interesting decisions where the refugee decision maker was willing to think about that, to sort of reflect on the gravity of harm that is visited upon a person when they don't have a nationality. And this, I thought, was one particularly interesting case from the US Court of Appeals for the Sixth Circuit. As I say in the slide, it's a rare case to consider the gravity of harm. But here talks about the essence of denationalisation is the total destruction of the individual's status in organised society. So regardless of what flows from that, the denial itself constitutes persecution. I think the final point I'll just make in terms of we've really been focusing, as I say, on the denial or the deprivation, but of course the consequences are really important, particularly in the context of socioeconomic rights. Now, civil and political rights are relevant too, but by far and away, most cases we found entailed a violation of socioeconomic rights. That is in fact what often led the stateless applicant to leave their country, and particularly when it came to their children. We found time and again, the narrative would be, well, I put up with this, I've lived with a life of degradation and poverty, but I don't want the same for my kids. And that's where I think, certainly stateless refugee applicants could enjoy success, but it's also quite challenging because the idea of socioeconomic rights violations constituting persecution can be challenging for some refugee decision makers, but fortunately there are some very positive cases as well. So I've got an example there from a Canadian case that basically critiquing the decision below, saying the panel, so the first level decision maker, didn't really properly assess just how serious these violations of socioeconomic rights were in the context of the stateless Palestinian in Lebanon in that example. But the final slide I'll leave you with is this quite recent decision from Australia, which I think is particularly interesting. It's about a child who, due to Lebanon's discriminatory nationality laws, the child is going to be stateless. And the tribunal, so this is it's not quite the first level, but we don't always see really progressive decisions at this level. And sure enough, the tribunal member is saying denial of education, healthcare, residence, etc., is unquestionably serious harm. I think indicating the potential for these cases to be argued, particularly in the context of children. So I'll sum up. In principle, I think, as I've mentioned, there is significant scope for the protection of stateless persons in refugee law. And as I said, I think it's a really important source of protection. As a number of appellate judges have noted, if the refugee claim is rejected, a stateless applicant can remain in limbo, and in some countries, including my own of Australia, this can result in indefinite detention. So for example, we have one stateless applicant or stateless person in detention who's been there for 10 years because their refugee claim was rejected and there's no visa category for stateless persons in Australia. Hence, in our book, we call on refugee advocates, lawyers and decision makers to ensure that their understanding of the rights of stateless persons in international law is not mired in outdated doctrines, but rather reflects contemporary developments in human rights law. Now, while statelessness does not per se constitute qualification for refugee status, in our view, a careful application of human rights law suggests that it may do so in a great many cases. Thank you.
Thank you so much, Michelle, for a quite amazing distillation of your book and a plea for a more sophisticated understanding of statelessness as a ground for claiming refuge. So our next speaker is a practitioner. It's Laura Parker, who is a protection officer with IOM. She is based in Nouakchott, Mauritania. And she is going to focus on what IOM plans to do in Mauritania with regard to stateless people, and also speak more generally about IOM's strategy on statelessness. Laura.
Good morning, everyone. Thank you very much, Beth. Thank you, Michelle. So I'm going to talk about migration generally, so not just mixed flows, but also issues of statelessness as they relate to first and second generation migrants. So that means I will be covering both in situ populations and contemporary stateless migrant populations. And just a quick note on terminology, because we often use the phrase historic migrants, but let's be clear that this is actually an in situ stateless population who are descendants of people who were once on the move. I wanted to make a quick point about this idea of invisibility, because I think it's a common theme running through both work on mixed migration and on statelessness. So whether you're talking about identifying refugees amongst mixed flows or others in need of international protection, survivors of trafficking, or whether you're looking at caseloads who you're trying to evaluate if they are or aren't stateless. It's often something that affected populations don't necessarily know. I've often heard stateless people say, no, I'm Ivorian, or victims of trafficking that I'm currently working with will say, no, it's good money, I can go home if I want to. So there's this idea of invisibility and difficulty in recognizing the issue. And the reason that I want to stress that idea is because I feel that actors working on statelessness often see stateless migrants as a sort of easier issue to deal with, that the issue of contemporary stateless migrants sort of against the bigger picture of more protracted in situ caseloads is much more visible and easier to deal with. People arriving at a border, they're already stateless. It's not the fault of the country in question. You can deal with it with a relatively simple solution of a status of stateless person leading to nationality in theory, as opposed to populations whose presence is linked to a much more deep-seated issues of exclusion that you could only deal with through concerted efforts on social cohesion or often controversial legal reform. And I think in Africa especially, if we look at the global I Belong campaign and the UNHCR's Global Action Plan, this Action 6, which talks about granting a protective status of stateless person to stateless migrants, is often seen as a very low priority, relevant only once you've dealt with much larger, more complex, entrenched issues and in situ populations. You'll see national action plans on statelessness that sort of put it right at the end and gloss over it. You'll have 10 detailed actions on birth registration or legal reform, perhaps because this is seen as something so far in the future, just sort of enact a semi-protective status of stateless person, create a statelessness determination procedure, and ensure these individuals end up on a pathway to nationality. And in trainings, you often stress the difference between the approaches that you must adopt for the two different types of populations. Stateless people who are stateless, who are there where they were born and where they've always lived, whose inclusion can only be facilitated by legal reform, as opposed to people who are arriving and it's not by reforming your laws that you're going to resolve their situation of statelessness. And these people are presumed to be much more easily identifiable and visible. But I don't think this is the case, and I'm glad Beth mentioned complexity in the introduction, because we're going to come back and look at different groups within that sort of caseload of stateless migrants afterwards. Oh, I had slides. Which way? I wanted to have a quick look at just some of the terms in the Global Compact on Migration. On legal identity. And I think it's really interesting. I'm not going to read it, but especially the highlighted bits show us that this is often framed as an issue that states must address on account of their nationals abroad, as opposed to a minority issue. And I think that could be interesting for us to sort of help build support around an issue that's often seen as taboo or controversial, because it kind of conveys the message that statelessness could affect you. It could even affect elites living abroad who could technically encounter difficulties in proving their belonging or their nationality. And there was another thing that I found quite interesting. There was a blog recently on the LSE site by Stephanie Grant about consular protection. And she said consulates have largely been invisible in discussions of migrants' human rights. Their role in protecting nationals abroad has tended to be forgotten, with priority given to the development of migrant protection under human rights law. So you have consular law, which is sort of rooted in these reciprocal interests of states protecting their nationals, and then this converges with human rights law, specifically on the issue of issuing identity documents. And I'm not sure if Alvaro is going to talk about the Convention on the Protection of Migrant Workers, and consular assistance is essentially protected under human rights law in Article 23. And I think there's more of a spotlight on consular assistance as a solution to statelessness in migratory contexts. Oops, let's go back and forwards. So just some words on what is IOM doing in terms of engagement with these issues of both statelessness and legal identity, and what more it could be doing. There was an internal survey done of all the operations, all IOM country missions, to sort of get an idea of what they're doing on this issue. And it's often that people have actions that contribute to prevention or reduction of statelessness, but they're certainly not perceived or conceptualized as such. IOM has joined the legal identity experts group on statelessness, on legal identity, the coalition, I think, on every child's right to nationality, and there are joint studies that have been published with UNHCR on statelessness and migration, particularly in Africa. But I want to look at how these examples could go further. So IOM does a lot of work in terms of assisting migrants to access documentation. The examples are from Colombia, where we've worked with IDPs to get civil status documentation. Libya, in detention centers, quite interesting, where IOM has put in place a consular Skype service so that detained migrants can access their consulates and obtain documents. But it's often, IOM does a lot of work with regards to voluntary return and reintegration. So these documents are often one-time travel documents. And I don't see any reason why you couldn't work out mechanisms to go further and actually support consulates to issue much more protective ID documents rather than just laissez-passer for one-time use. Just a point, nobody is saying that we have to be careful not to say that all undocumented migrants are necessarily stateless or even at risk of statelessness. There are some who are. Some people will be confirmed as nationals by their consulates, others won't be. And I think this is another area where IOM could reinforce its work on statelessness, so by advocating for adherence to both official but also simplified procedures for nationality determination by consulates based on laws that are in place, and which have alternative options for people who perhaps can't substantiate their claim to nationality. If they don't have the documentary proof, is there witness testimony? Are there mechanisms that can be used? And also ensuring that consular officials don't, I've seen myself, consular officials confirm nationality based on somebody's surname or scarification and other things that really require a much more uniform approach. And I think the reason I'm saying that is also there might be, and I'm talking also from experience in the Ivorian context, which was actually with UNHCR, where you see, the Burkinabe consulate is very willing to confirm nationality of Burkinabe origin, and people who are born in Burkina Faso and now live in Côte d'Ivoire, they're very willing to confirm them as their nationals. And I think you can have the possible downside to this might be creating a lack of faith in consular documents. Consular cards might not be given much weight. And I don't know if Nina is planning on saying anything about this in the European immigration detention context, but when there are reasons for consulates or other authorities to not recognize people as their nationals. Because ultimately there is a need to ensure that people who are refused as nationals through these consular nationality determination processes are somehow put on a pathway to nationality, even via a temporary status of stateless persons. I'm not going to say much about technical advice and advocacy for legal reform. I think they go hand in hand, and IOM could certainly get involved where there are heightened risks of statelessness for migrants. Laws that sort of cut off jus sanguinis entitlement to nationality after a couple of generations of nationals born abroad, without safeguards against statelessness. Or laws making it, for example, harder for migrant women to pass nationality onto their children as opposed to men. And I think what's interesting about IOM is that it also has the capacity to engage kind of non-traditional interlocutors, at least for the field of statelessness, in these discussions on legal reform. So given its experience in border security, border management. And perhaps also on legal reform, this idea of facilitating access to proof of nationality via consulates can lead to reflections on, do the existing legal frameworks enable this? Do they enable consulates to give proof of nationality? So perhaps a word, and yes, I know IOM is developing principles, guiding principles for internal use on how to address issues of legal identity and or statelessness as they arise. And that brings me to sort of this idea of breaking down the caseload of, migrants who don't have documentation, who may be at risk of statelessness. Perhaps also it's important to say something about complementarity, because there are a lot of actors, at least in the UN system, working on civil status issues. It's quite trendy, this topic, and it's important to look at how tasks are divided up, where UNICEF can play a role, where UNHCR can play a role, and where IOM could leverage its experience in consular liaison for some of the complex cases that can't necessarily be dealt with in country. And that was a discussion that we started yesterday in the birth registration session about how when we talk about birth registration, we're always looking at what happens in country, and we should always think as well about does a country's frameworks, 2 minutes, okay, allow confirmation of identity for people born abroad. So just really briefly, it's quite complicated. You have people who are born abroad who were declared and who just need to recover a copy of documentation that they once had. Can requests be channeled through ministries of foreign affairs? Can they be done online? Then you have people who were never documented. So they might have declared their birth, they might have been registered, but they never got a copy of a birth certificate because it might have been expensive. Or people whose birth was simply never registered and now they're in another country. And in many, for example, civil law countries, late birth certificates are issued by a judge. It has to be done in the area where the person was born. You have to produce witnesses. It's complicated. There was an interesting, it ultimately didn't happen, but there was an interesting joint Ivorian-Burkinabe initiative that was set up in late 2016. This was with UNHCR, whereby Burkina Faso judges were going to come and issue late birth certificates to their nationals and nationality certificates born in Burkina Faso but living in Côte d'Ivoire. So the way that we got around this idea of extraterritorial jurisdiction was that the judges were going to be sort of delegated as consular officials. And yesterday we heard from other practices, Lebanon, Mexico, about how there are simpler ways to, in certain legal systems to deal with this. I won't talk about the even more complicated case of people born in transit. Perhaps just a last word then on Article 25.2 on administrative assistance in the Refugee Convention. I'd be really keen to hear of examples where this is invoked for host countries to issue documentation that would normally be issued by authorities of a country of origin. And also, if anybody has experiences of working with consulates to confirm nationality. I think that was kind of the last point. If you'll allow me maybe one last point, I won't read out if, I'm encouraging people to sort of flag to IOM in the context where they work if they could be a useful partner. Obviously, there are heaps of challenges, and we need to do more to ensure it's translated into concrete programming. But the last word was on, and I think Hervé might be speaking next, on statelessness determination procedures and catalyst cases, because I think this applies to all actors, where statelessness is often deprioritized in the face of compelling humanitarian imperatives. Yet suddenly you find these cases of stateless migrants, which nobody knows how to deal with. I'm not sure if Irina was here, but we had a really complicated case last year, Uganda, Ukraine. There was the case of a Bidoun person with a Comorian passport who sat in JKIA airport for weeks last year because he couldn't go anywhere with that passport, and he was forced to lodge an asylum claim to exit the airport. So I know Hervé will expand on the idea of SDP, statelessness determination procedures, but I think it's right not to prioritize these where you have huge in situ caseloads, because it can be a distraction. But it's not unconvincing that this could be a sort of low-hanging fruit where you resolve other caseloads first when bigger in situ situations are too politicized, or as a means to drum up interest around statelessness generally. So that's all I'll say. There's lots to do, and let's work together. Thank you.
Thank you, Laura, for all of those alternative options and creative ways that consulates can deliver documents to stateless people. Our next speaker is Hervé Coité. Hervé is Senior Regional Protection Officer on Statelessness at the UNHCR Regional Office in Dakar, West Africa. He is going to talk about the complexity of some of the migratory movements across borders in West Africa, both historically and currently, the situation of Niger as a de facto gateway to Europe and UNHCR's role there, and finally, the ways that stateless people can be identified. Hervé.
Thank you very much, Beth, and hello, everybody. I'm very happy to speak on in a session where we are actually discussing the protection of stateless people, because so many times when we discuss about statelessness, we actually see it from a prevention perspective. And it's just as if, indeed, being stateless is something abnormal legally, which is shameful, but I'm afraid that this shame may at time and too much of the time eradicate the 1954 convention itself. It's as if people are ashamed to talk about the convention and to talk about protection. So I'm so happy to talk about this. And my point here is that more vivid engagement on protection does no harm to prevention of statelessness, and that mixed migrations or mixed movements, as we like to put it within UNHCR, that mixed movements provide a very unique window of opportunity to focus on protection, which indeed starts with statelessness determination procedures. And indeed, all this should lead to solutions. First and foremost, naturalization. I would like to speak from a few field examples coming from the field, indeed. And but before I go into the case of Niger, as Beth mentioned, I'd like to highlight contemporary migrations as a complex phenomenon from the perspective of UNHCR, and to us, the word mix really bear a lot of sense because it does highlight the fact that we do have various categories of people caught into these flows. And these categories include refugees and stateless people who are indeed entitled to international protection. So to us, it's so important to term these movements really as mixed movements. And even sometimes, we do prefer to escape the terminology of migration and really stick to movement, again, to highlight this fact. So in the case of Niger, which with the security, the political and security situation in neighboring Libya, has de facto become the border with Europe in terms of the migration movements we have all been witnessing, at least on the media, for the past few years. So in the case of Niger, we do have a variety of migration patterns, both upstream to Northern Africa and to Europe, through the desert, the Sahara Desert and the Mediterranean. We do have downstream movements back to Africa, back to a number of countries in Africa. But first and foremost, Niger is a transit country. So many people pass through Niger to continue their journey through other places. If I can very quickly mention a few statistics from IOM in Niger. In 2018, IOM in Niger has established that a minimum, and these are really minimum and indicative figures, that outgoing flows from Niger stood as 1,600 in French, 106,000, 1,600, whereas for the same year, incoming flows into Niger stand at 88,000 and plus, 88,000. So indeed, these are already huge numbers, But if they are to be compared, even with the same, with the figures also reported by IOM for 2016, still in Niger, outgoing flow stood at more than 300,000 people from Niger. So for us as UNHCR, it becomes very clear and very key that we have to do something to identify persons of concern to UNHCR, meaning persons in need of international protection who are caught in these migratory flows. And we have been working quite a lot with a variety of stakeholders, including, and indeed first and foremost, the government in Niger, to try and identify persons of concern to us, including stateless persons or persons at the risk of becoming stateless. And this speaks a lot. This is indeed a very collaborative effort, speaking a lot to the provisions of the Global Compact on Refugees, and especially to the provisions of paragraph 60 of the Global Compact, which indeed calls for such a collaboration and which actually calls for establishment of statelessness determination procedures. I would like to read extract of this paragraph for us here, which reads, in support of concerned countries, states and relevant stakeholders will contribute resources and expertise for the establishment of mechanism for identification, screening, and referral of those with specific needs to appropriate and accessible processes and procedures. This includes identification of international protection needs of victims and support, and identification and referral of stateless persons and those at risk of becoming stateless, including statelessness determination procedures. So this speaks a lot to what is in the Global Compact on Refugees. This speaks a lot to what is in the Global Action Plan against refugees, especially Action 6, and my colleague from IOM mentioned that. So we do see SDPs, statelessness determination procedures, in that context as a tool to identify migrants, and really as a necessary tool. And we are very happy that in that context we can rely on the support of the Economic Community of West African States, the ECOWAS, which has adopted not only a very clear and very strong Abidjan Declaration against statelessness, which has now become a little bit famous, with also a plan of action, the Banjul Plan of Action, under which the ECOWAS has committed to actually come out with a model law on statelessness determination procedures. And I'm very happy to see and to report that a number of countries in West Africa are actually moving toward establishing such statelessness determination procedures. We just had a workshop last month with 6 of the countries in West Africa, and we came out from this workshop with country-specific roadmaps towards the establishment of SDPs. So West Africa will very, very certainly become, in the coming year, probably as early as of 2020, next year, and a region from where we will have new and fresh SDPs. And indeed, this is I believe this is very good, very fortunate. This is a very good and very strong signal, which also speaks to the move toward establishing SDPs in other regions in the world, in Latin America, in Europe, and so on and so forth. So my first point then is to again point out that this move toward establishing protection regimes to ensure that stateless people do have access to the rights enshrined in the 1954 Convention is key, and that it starts with statelessness determination procedures, which are so relevant, especially in migratory context. But we do also have other type of situations of statelessness. And again, Laura from IOM spoke to that a little bit. And she mentioned about the situation of people who are in situ, for whom indeed, as UNHCR, we do have a very firm and a very clear stand that SDPs should not be the way forward, because we believe that, generally speaking, it is not quite pertinent to to ensure access to a protection status as stateless person to people who have always been, to people who have been born in their country and who have been living there all their life. However, in some of these in situ situations, the linkage between actual in situ-ness, so to speak, and migration is very thin. And we do have to interpret this doctrinal position of UNHCR, also reflected in our handbook on protection of stateless people, in a very cautious way. And I would like to elaborate on this by taking two examples from the field again. One in West Africa, Ivory Coast, and the other one, if time allows, in DR Congo. In the case of Ivory Coast especially, this is a country where historically and during the colonial era, there have been a lot of population transplantation, especially from neighboring Mali and Burkina Faso into the country, first and foremost for agricultural purposes. People came to work on farms. Indeed, half of this population, tens of thousands of people, were from Burkina Faso, but also a little part of them were from other countries, especially Mali. And the flow continued after the independence in 1960. What is quite maybe shocking, but at least very, very obvious, is that 26% of the population of Ivory Coast, according to a government census conducted in 1998, 26% of the population are actually non-indigenous, are actually from a migratory background, and are basically non-citizens and do refer to themselves as being foreigners. And half of these 26% who are non-indigenous are actually born in Ivory Coast, but they do not have any ground to claim the citizenship of Ivory Coast as such, and they do not necessarily have enough link with another state to claim the citizenship of that particular state. So it is a situation where we do have a statelessness in situ situation which has a very, very strong linkage with a migration history of ancestor, of some of the people, having moved from some of the neighboring countries. Indeed, again, we do not believe that SDPs or granting a protection status should be a way forward here. But very interestingly, there have been a mapping exercise in Ivory Coast, whereby the government and UNHCR and a number of stakeholders have come together and tried to understand where the stateless people are and what is their profile and what is it that is making them actually stateless. And the result of that study are yet to be published. I hope they will be announced maybe during the UNHCR NGO forum in the coming days in Geneva, where Ivory Coast is participating. But what we know is that probably the figures of stateless people in Ivory Coast from that study will go up a little bit high. And as part of the follow-up on the result of that study, the idea is to work with these neighboring countries, Burkina Faso, Mali, and so on, to try and confirm nationality and basically grant documents which will help people claiming a citizenship. But indeed, it is predictable that there will be a remaining caseload of people that will not be able to be linked to any nationality. And at that time, it will very certainly be necessary to call them by their name, which is they are stateless people, and we have to ensure that they do have access to that status enshrined in the 1954 Convention. And from there on, we should be able to find solutions. Indeed, a number of legal reforms have been occurring in Ivory Coast to address this issue since the 90s, basically. The latest one is probably the law of November or December last year that seeks to ease the access to proof of citizenship documentation, including in cases where people have acquired fake identity. For sake of time, I won't go deep into the issue, the situation in Congo, but we do have a very similar situation where there have been population transplantation from neighboring Rwanda and Burundi into Eastern Congo, which has culminated into an identity crisis. Is the whole issue of Banyamulenge, Banyavyura, which some of us may be familiar with. And this is also indeed very much linked to the various rebellions and continuous insecurity situation in that country. And again, the line is very thin between formal or blank in situ-ness and the background and the migratory background behind this movement. So I want to conclude by saying again that as UNHCR, we do believe that mixed movements really provide a very unique window of opportunity to focus on protection, which indeed, again, should start with statelessness determination procedures. Thank you very much.
So thank you, Hervé, for really explaining that very thin line between statelessness occurring from historical migration and current migration. Our next speaker is Nina Murray, who is Head of Policy and Research at the European Network on Statelessness. She's going to talk about their work on statelessness in a migratory context and also focus on the findings from their Stateless Journeys project, which examines the nexus between statelessness and forced migration. Nina.
Thank you, Beth. Good morning, everyone. Thank you, Beth. So as Beth said, I'm going to talk a little bit about some of our work at the European Network on Statelessness in Europe. I'm going to use a few slides to keep you all awake, because I'm aware that you've been sitting for a long time listening to us talking at you. So I'm sure most of you by now know the European Network on Statelessness, but just very briefly, we're a civil society alliance of about 140 organizations, individual experts, academics, lawyers, NGOs, community groups in 40 countries here in Europe, working to some extent across all of their work to address statelessness. And our work is kind of divided up into three core pillars. So we do awareness raising, we do training and capacity building, and we do law and policy development. And our work, if I can make this work, that corner? Nope. Maybe Helene can do it for me. Thank you. So our work is broadly based around these four priority areas. So children's rights, access to justice, forced migration, and anti-discrimination. And as you can see, all of that work, in all of that work, there's an intersection with migration to some extent, but we also work on in situ statelessness in the European context as well. So just to kind of highlight these core areas. Today, what I wanted to do is share... Oh, no, too far. Oh, maybe it's not too far. I've forgotten which order they're in. Okay, it's not too far. Yeah, you can switch to the next one. Sorry. So what I want to do today is share some of the challenges that have emerged from this project called Stateless Journeys that we've been carrying out over the last year or so in partnership with the Institute on Statelessness and Inclusion and with many of our, or a handful of our members in different countries in Europe. And what this does is really looks to try and better understand the nexus between forced migration and statelessness in Europe. And in many respects, this picks up on a lot of the issues that have been touched on by my colleagues here on the panel today. And what we wanted to do, we heard from our members, many of whom are refugee support organizations or migrant rights organizations, that statelessness was an issue in their work. But the issue of statelessness and nationality rights has been very absent from the migration and asylum debate in Europe. And we wanted to understand why that was. We wanted to understand better what this experience of being a stateless refugee was like, and also how statelessness and nationality rights were being dealt with by policymakers, by frontline officials, by NGOs, how it was understood by stateless refugees and communities themselves here in Europe. So what these statistics tell us is that there's been an increasing number of asylum applicants, this is an example from the European Union database, arriving and being recorded as stateless or having unknown nationality since 2015 or 14 in particular. You can see these rising numbers. So we know even in the data that this is an issue. And actually, when you look in more detail at the data, over 100,000 asylum applicants to the EU were recorded as stateless or having unknown nationality between 2015 and 2018. So they're quite significant numbers. But we also know that many more people go undetected in the statistics. So the data is only as good as the recording of that data, and there are likely to be many more. However, we also saw that European countries really lack frameworks. Most European countries don't have statelessness determination procedures in place. Most don't have identification guidance on how to identify statelessness in place. So nationality problems also go missed. They go unnoticed. And more importantly, the voices and experiences of stateless refugees are really absent from the debate as well, and they're rarely heard. So this is why we developed our Stateless Journeys project. We got together, as I said, with the Institute on Statelessness Inclusion and some of our members, and we aim to examine this impact of statelessness on refugee journeys and to develop, importantly, develop responses, so develop tools and resources to address these challenges. I think, yes. So we have produced this website that you can all access, statelessjourneys.org, to host the findings of this project and to be a kind of working platform on an ongoing basis for resources as we develop them. So what we did is we carried out some initial research, and we did that in 3 countries, so in Greece, Serbia, and the Netherlands, with our members in those countries. And we spoke to stateless refugees, we spoke to national authorities, we spoke to civil society, and then we also spoke to regional stakeholders like UNHCR, like Frontex and other EU agencies, and refugee representatives at a European level as well. And we also carried out a corridor study. So our member Thomas, who's here, he looked at a particular community that was affected by statelessness, or communities. So he looked at stateless Syrians and their journey all the way from the Middle East through the Greek route and up through into the Netherlands, and what were the different issues that they were facing on that journey. So a kind of corridor approach as well as the in-country approach. And on the back of that, we've started to develop tools, as I said, and resources for awareness raising, capacity building, and engagement to disseminate these findings and to try and push for policy solutions. So, thanks. So some of the resources that we've developed include country of origin information. So one of the things we identified was a real lack of country of origin information that identifies statelessness and nationality problems in countries of origin. So this is, we have one on Myanmar, one on Kuwait, and we're developing other country of origin papers on Syria, Iraq, Iran, and Palestine. We also published the research findings in a report, and there are copies of that report on our marketplace stall, so please take them. We don't want to take them home, so please take some. It's also available on our website. And we also developed some country briefings and translated these into different languages. So we have here, for example, a Greek language briefing on statelessness in the Greek context, refugee context. And we also, thank you, Helene. We're also carrying out advocacy and engagement activities. So in this slide, you can see examples. We have been working with the Frontex Consultative Forum to try and get them to focus more on what Frontex needs to do better when it comes to identifying statelessness. Frontex is the EU border agency, and they have a role in, for example, Greece in new arrivals, registering new arrivals. And we found, as I'll tell you about in a minute, some issues with how they were identifying nationality in that process. So we've managed to secure 5 recommendations to the Frontex board by the Consultative Forum, and they're currently being considered. So step by step, we'll hope that they implement those. We've also been speaking to stateless refugees and refugee representatives in different countries. So we were in Greece 2 weeks ago, and we held 2 workshops in Athens and 1 in Lesbos, and we asked them what statelessness means to them, what some of their priorities were, and what more they needed from us in terms of information about their rights and entitlements. And we've also been speaking to lawyers and civil society. So we managed to get 25 lawyers in a room in Lesbos in a very hectic context because they were really keen to get information about statelessness. They were seeing it in their work, but they didn't really know how to respond to it and what to do about it. So this shows that there's a real need for capacity and awareness on this issue. So what were the key challenges that arose out of this project and this work? So, thank you. Firstly, there's a big knowledge gap. So there's very little awareness of statelessness among refugee actors, among refugees themselves, among even lawyers, not all, but the kind of majority, among civil society, and especially among frontline officials and authorities. A big knowledge gap was kind of the overall finding of the project. And as well as that, we found issues in these 5 key areas. So the first area on the top left is around identification. So I already mentioned it. Identification and recording of nationality status on arrival. So we talked to people who had experienced instances of imputed nationality, so authorities telling them what country they're from or what nationality they hold. And we saw this happen in many instances with Kuwaiti Badoon, who were assigned a nationality, Iraqi, for example, quite often, on their records, and that has an impact on how they move through the asylum procedure in Europe. So if you're recorded as Syrian, it's very different than if you're recorded as unknown nationality or as Palestinian or whatever else. So it matters what's on your record when you arrive, because that moves with you through the procedure. The second area was status determination, and Michelle has talked about this already, but issues around whether statelessness is perceived as a protection ground by asylum authorities. We saw issues where credibility was questioned because someone's nationality had been recorded one way on arrival, but then they were trying to say to authorities, no, but that's not my nationality. And then authorities saying, well, why did you say it was? And they're like, well, we didn't say it was. This was recorded. So it can get very complicated, and this had an impact on how people were perceived in the procedure. And other issues also arose around other protection routes, like access to resettlement procedures, access to family reunion was a big problem where nationality was unclear or family links couldn't be established. Then we found issues with the child's right to nationality. So this has already been touched upon by Laura, for example, issues about birth registration. So are births being registered? What impact is that having on children's nationality rights further down the line? We found also lack of awareness about safeguards and nationality laws for otherwise stateless children born in Europe to refugee parents, and that these safeguards, where they exist, are maybe not being implemented in practice because nationality problems are not being identified. We also found issues with detention. So Locked in Limbo was a campaign that we ran a couple of years ago around preventing arbitrary detention of stateless people. And we found that due to the lack of statelessness determination procedures, due to the lack of protection mechanisms for stateless people who perhaps weren't recognized as refugees, because statelessness is not being identified, people end up in cycles of return procedures, detention. Return can't happen because there's no country to return them to. They get released, but they're no legal status, so they face detention again, and this was happening. And then lastly, the fifth one is around durable solutions and access to naturalization. And Laura van Waas mentioned this yesterday, if you heard about these problems with inflexible procedures for naturalization. So even if someone is recognized as stateless, it can be difficult to access a nationality, so the routes to nationality are limited. And then my last slide, I think you might have to click 10 times because they're very briefly, these were our recommendations. So these are all available in the report that's outside, but what do we need to do to address these challenges? And these are some of our recommendations for ways forward, and it'd be really interesting to hear whether these issues are arising in other contexts, in other refugee contexts, in other continents, for example. But the main recommendation I want to highlight today, I'll choose a few. So clear procedures and guidance for nationality screening is really clear. We need to be identifying nationality problems. Even if someone is recognized as a refugee, there could be a cessation question further down the line, and statelessness, even if they're protected, statelessness might arise later, 5-10 years down the line. And what happens then? If we're not identifying statelessness early on, there are impacts throughout people's journeys. Building capacity, developing accessible information for individuals affected. This is really missing. People need information in their languages that they can access about their rights. More statelessness determination procedures, immediate birth registration and certification. So you don't always get a birth certificate even if your birth is registered, and that has implications further down the line for the child's right to a nationality. And lastly, really important, I think, is that we need to understand this better. We need more research, we need more focus on this nexus, it needs to be more visible in the debate, and we need more resources to continue this work. So, thank you.
Thank you, Nina, and to ENS for laying out the many gaps in identifying stateless people in Europe. So our final speaker, last but not least, is Alvaro Botero Navarro, who is a human rights specialist with the Inter-American Commission of Human Rights, and is here as a member of the Committee of Migrant Workers. And Alvaro is going to focus on the Americas, I believe. Thank you.
Sorry about the voice, but I've been having some problems with my throat. Good morning, everyone. Well, as it was mentioned by Beth, I'll be addressing the situation of statelessness in the Americas, and also some of the measures that has been taken at the national and regional level by the regional bodies in order to address the situation of statelessness in the region. Stateless persons in the Americas is a current problem in many countries. There are certain situations that can be identified as the main focus of attention right now, particularly the historical situation of stateless persons in the Dominican Republic. Also, one of the new dynamics that we are facing in relation to statelessness or risk of statelessness relates to the situation of the children born of Venezuelan nationals who are migrating to other countries of the region, particularly the case of Colombia. And we also have situations in the Caribbean, in countries like Bahamas and Barbados, where mothers cannot confer nationality to their children. In relation to the case of the Dominican Republic, I suppose you have already heard a little bit about that situation, which might be like the most classic case of statelessness in the region, but also the largest situation that we have, even though we haven't have clear numbers about the amount of person who is stateless right now in the country. According to the last figures that were released in 2016, there were about 133,000 people who were stateless in that country. The government ended up depriving of their nationality the children of Haitian migrants as an historical process that was during which the government was taking several measures in order to restrict the nationality of children born of Haitian migrants in the Dominican Republic. The last episode of this process of historical discrimination against the children of Haitian migrants relates to the decision of the Constitutional Court of 2013 that retroactively stripped of the nationality from anyone born of Haitian parents since 1929. According to the last information released by Dominican authorities, there has been around more than 26,000 people who has received nationality documentation by September of 2018. The solutions that were provided by the Dominican state were divided and were adopted by the Law 169 and divided the group of people affected by these measures in two groups, Group A, Group B. Basically, Group A were those children born of Haitian parents who were able at some point to be registered by the civil registry, and Group B was that of who were not registered because of several reasons. For those who had the luck to be registered by the civil registry at some point, they were able to be granted nationality, but there has been many troubles or many problems in terms of receiving the documentation for this group. And for the other group, as there has been mentioned by some of my predecessors, they were considered at the initial step as migrants, and after a regularization process, they could also apply for naturalization. But there hasn't been much clarity about how this group of people can end up having recognized their nationality, and the number of people who has presented naturalization claims until the end of 2018 was just 308 people. In relation to the cases of the Bahamas and Barbados, the Bahamas and Barbados remains like the only countries in the Americas that prevents mothers from conferring nationality to children on an equal basis with fathers, because they do not have the right to confer nationality to the children born abroad. In addition to this, both countries deny fathers the right to confer nationality on children born out of wedlock. Also, for persons born in the Bahamas to married non-Bahamian parents, they might apply for Bahamian nationality between their 18th and 19th birthday only. For example, for young people born of Haitian parents who do current laws have not an automatic nationality, they have to wait until their 18th birthday. And an additional challenge in relation to this is that there is no available data on the figures of the people who is statelessness or at risk of statelessness in these countries. And the other significant case or situation that we are facing in the region, and it's more recent, relates to the situation of the children of Venezuelan migrants and refugees who are born abroad. According to recent figures, there might be approximately 20,000 stateless children, especially in Colombia. The problem in the case of Colombia lies in the fact that according to the Colombian Constitution, the children of foreign-born nationals that are born in the territory are not Colombian nationals. There are, according to Article 96 of the Constitution, 3 avenues through where people can get Colombian nationality. One of the parents is a Colombian national. The parents have a visa issued by the Ministry of Foreign Affairs, or they can adopt the nationality when they have been living for more than a year with a visa and decide to apply for nationality. This is an issue that has been addressed since 2009 by the Committee on Migrant Workers, which expressed concerns about this situation and recommended the state to ensure, both in practice and in law, the right of all children to have a name, to have a registration of their birth, and to have a nationality. In addition, the children of Venezuelan born in Colombia are at risk of being stateless because they also don't know how to receive or how to get the nationality of their parents in their country of origin, due to several barriers ranging from the lack of knowledge to carry out those procedures, but also because of obstacles imposed by the Venezuelan consulate authorities. In this sense, I think it should be highlighted that the Colombian government has been taking measures in order to address the situation. For example, in 2014, the Colombian government ratified the 1961 Convention on the Reduction of Statelessness. Later on in 2017, the government established a special procedure to address these cases containing the Circular 168. And there has been also very interesting developments by national courts. For example, in 2018, the Constitutional Court, in its decision 23 of 2018, the court asked the register office to register a girl's birth, even without out of the formal registration window, without complying with all the formal requisites, but if she can appear before the register office with at least 2 witnesses who certified her birth. Also, there was a very recent decision in April of this year, the Office of the Ombudsperson in Colombia presented a bill in order to address the situation in the law. And this basically focused on determining that sons and daughters of Venezuelan foreigners in an irregular situation born in Colombian territory since 2015 and up to 1 year after the enactment of this bill might be given nationality. Proof of nationality is the civil registry of birth, or failing that, the certificate of live birth in Colombia without the requirement of domicile. That's kind of like the main obstacle for Venezuelan, for children of Venezuelan born in Colombia in order to get nationality. Also in relation to judicial decisions or from national courts, there is a recent decision from Medellin Superior Tribunal in the case of Cristian David Primera Aguas against the National Registry of Civil Status. And the court decided to order the birth registration of a son of Venezuelan nationals because his parents didn't have their domicile in Colombia for the date of his birth. Another thing that is very interesting in relation to this case and also in relation to other cases decided by national courts in Latin American countries is that the court makes a conventionality control and uses the standards developed and the norms of the Inter-American system in order to get to the decision to grant nationality to these children. In this case, they use the standards developed by the Inter-American Court in the case of Gianni Bosico against the Dominican Republic. A last development made in Colombia was that the Senate approved the bill that was presented by the Office of the Ombudsperson in June 19, and also the government presented or is about to present a project of decree in order to address the situation of children of Venezuelans born in Colombia. In terms of regional actions, I must say that there has been some very positive developments, and I should recognize the important role that has played the UNHCR in the region, leading these processes and creating the connections between all the stakeholders, civil society, academia, states, and also regional bodies like the Inter-American Commission. Basically, the channels that has been used in order to move regional processes in the Americas has been the I Belong campaign and the Global Action Plan to End Statelessness. As you know, the I Belong campaign proposed to states a global action plan to end statelessness, focusing on solving the primary situations of statelessness, preventing the emergence of new cases of statelessness, and identifying and protecting stateless persons. Another mechanism that has been used in relation or to address solutions for stateless people relates to the Brazil Declaration and Plan of Action that was adopted by 28 states and 3 territories in Latin America at the end of 2014. This plan of action has a program focused on eradicating statelessness and recommends the implementation of several measures. The first measure relates to the accession to the Statelessness Convention. The second recommendation relates to the harmonization of internal legislation and practice on nationality in accordance with international and inter-American standards. The third measure is relating to the establishment of effective statelessness status determination procedures. And the last measure relates to the adoption of legal protection frameworks to guarantee the rights of stateless persons. 2 minutes? Okay. Since these processes has started, we can notice that in the region, 11 countries have acceded to the Convention on Statelessness. There has been 6 nationality regulations that has been modified to prevent statelessness, and there has been 6 regulatory frameworks that has been adopted to protect and facilitate the naturalization of stateless migrants. I would also like to mention some of the measures that has been taken at the national level, but if you want, I can address that at the end of my presentation, but I should highlight that countries like Panama, Uruguay, Paraguay, Haiti, and Chile has adopted measures in the last 4 or 5 years in order to prevent statelessness or to facilitate the protection of a stateless person and also to give them access to naturalization in those countries. In conclusion, I would like to say that the outlook in the Americas, it's kind of promising, but I will agree with Nina that some of the challenges that we are facing in the Americas are very similar to the ones that you are facing in Europe, and the recommendations that you presented for Europe can be also applicable in the case of the America. I think there are serious or very serious challenges in terms of identification and screening procedures. Data collection is a very sensitive issue with many states, well, with some states in the region. We also have very few stateless determination procedures in the region, but we must recognize that this has been kind of a new development in the region. So we are optimistic that in the next years we will be seeing more procedures in order to determine statelessness. There are also a few protection regimes at the national level. As I mentioned before, in order to promote these measures in the Americas, the role of actors like UNHCR, the civil society organizations, academia, and also the Inter-American Commission has been very important. Finally, I should also recognize the importance that national courts has in order to protect the situation of stateless persons that has been identified. A couple of last points that I would also like to mention and that might be of interest for you is that the rapporteurship on the rights of migrants at the Inter-American Commission on Human Rights also expanded its mandate in 2012 in order to address the situation of stateless persons in the region. And as you could see in the presentation of my colleague Yvonne Garza this morning, you can notice an increase in the developments of stateless persons since that moment to today. The last point is that the Inter-American Commission on Human Rights is at the time developing a process to adopt the Inter-American principles on the human rights of migrants, refugees, and other persons in the context of mixed migratory migration movements. And the idea with these principles is that they will reflect the existing international and inter-American law, but also the standards that has been developed by UN bodies and the inter-American bodies. So this is also an invitation for all of you to send inputs for these processes. Well, thank you for your attention.
So thank you, Alvaro. Clearly much to be done, but some very positive developments regionally in active national courts. We now like to open up the floor to your questions and comments. Okay, so maybe take three altogether. So this lady, and this lady.
Thank you, Alison Harvey. One of Nina's points was to promote facilitating naturalization, which is a requirement both of the 54 and the 51 Convention. Does that, with its weasel word, facilitate, have any teeth?
Maybe two questions for the America. First, I would like that you quickly highlight what are the current obstacles for parents of Venezuelan nationality in exile in Colombia once they have tried to register the children born in Colombia to the official register. I guess they may have to approach their consulate to register or to transcribe, as we say, la transcripción. Yo pienso que se dice también en español. I mean, it has been done at the consulate of Venezuela. I would like to know a bit the kind of obstacle they face and if it's related to a possible claim for international protection or claim for refugee status. That's one question. Then, and again, another question for you, I'm sorry. I would like, if you know more, maybe your colleague may help. I heard that in Brazil, there is a kind of accelerated procedure to ensure kind of a refugee status determination, but that moved directly to the solution step that could be access to the Brazilian nationality through naturalization. And I think it would be very good if you could edify a bit the audience about that, because we all know that getting a stateless status is, as my colleague Laura says, it's some kind of intermediary measure, and it doesn't necessarily solve the solution, access to fundamental rights. That's it.
Okay, first I want to thank you for bringing to the table this important topic. I think that nowadays it is one of the more important challenges for the ones who work with statelessness, or at least in my region, the Americas. And I just want to raise two issues here, and I may wish to hear your thoughts on this. The first one is, do you see as a threat the fact that some states are granting humanitarian permits for migrants, and these humanitarian permits allow them to have access to certain rights in the promotion of the establishment of a statelessness determination procedures? Because I have heard like some kind of arguments like, okay, but we are already granting them some rights, so why we have to create a statelessness determination procedure? Like, we are granting them an identity and access to rights, so why we have to create procedure? And the other issue here, and I would like to hear more about the European experience, is on data collection and databases. That I think this is a rising topic in statelessness. And how did you use this database? I know Europe has a database on due to the Syria situation and all the migration situation. How did you use this database to identify and direct our persons of concern to the appropriate procedures? That are my 2 points.
Okay. Thank you. So Nina, do you want to take your 2 questions first?
Is this on? Sorry, my nails are too long to do the switch. Really interesting questions. Maybe briefly on the facilitation question, Alison, maybe Michelle might have a legal brain to answer that one, but in terms of practice, how that's being applied in practice, it's an area that is really problematic across Europe, and you can see in our statelessness index, if you look up the access to citizenship sub-theme, countries are really performing very badly on this. And, you know, for example, the UK charges more than £1,500 to naturalise. That's not facilitation for adults. Just under £1,500. About £1,000 for each child. Other countries, you have to wait for 8 years or more. Other countries are very high language requirements. So we haven't really seen any examples of good facilitation. So what that means and how that's interpreted is an interesting question that I'll throw out to the lawyers and scholars in the room. I think the question of the replacement of stateless status with other protection statuses is a really important question and something we should all be thinking about. And we've definitely heard things said like, well, children have got refugee protection, so why do they need a nationality? They'll get one eventually. I mean, I've heard people talking like that. So this idea that, I mean, and that's refugee protection, let alone humanitarian protection that can be a much lesser form of protection in terms of rights and entitlements. So it's definitely something we should be alert to, and we definitely need to be advocating strongly for the application of the 1954 convention. This is countries who are signatories and have acceded to the convention. We hear this kind of dialogue in those countries as well. So it's something we should be alert to for sure. On the database question, so our statelessness index, if that's what you were referring to in the European context, is more of a tool for advocacy and research and information providing. We don't, if you like, it's not a quantitative tool, or it's not a tool that I kind of map stateless populations. What we do with that tool is present research data in an accessible way to kind of highlight where countries are or are not meeting their international obligations. So it's not a tool to, we're not capturing who is stateless, or where people aren't able to access us through that tool, if you see what I mean. So it's maybe a slightly different kind of tool from, if I understood your question, from what you were referring to. So the index is an advocacy tool, really. It highlights where the gaps are in different countries and where we should be advocating for change, and also allows you to compare good practices across different countries. We are trying to create resources that are more accessible to individuals affected, so that they can access the tool and find out information about their rights and what that means for them. And we're also trying to include in the tool somewhere on the website information, signposting information in terms of who you can contact in different countries for legal advice, for example. But that's the kind of tool that it is. So it's maybe something a bit different from what you'd described.
Yeah. Is this on? Yep. I might just jump in quickly about the facilitation, and I don't necessarily have a great response. I mean, I think, but maybe just to give it the legal background. So you're right, it's in both the 51 Convention and the 54 Convention. So if you're looking at international treaty and you're asking, what does it mean? Does it mean anything? You know, does it have teeth? You would look to, well, what's the adjudicatory body that has the power under that particular treaty to issue a binding authoritative determination? As everyone probably knows, there is no such body in relation to both the 51 and the 54. The other complicated feature is that while, say, the 147 states that have ratified the Refugee Convention, a huge proportion of those have brought down into domestic law the definition of a refugee, but very few have also brought down the rights regime. And so while you can say, what does persecution mean, and look at domestic courts, it will answer that question, or at least help you to answer that. I mean, I'm not aware of any domestic litigation that's tried to look at that. However, we shouldn't give up. I think what we should be thinking about is, well, I mean, I think the notion of good faith, sometimes people just sort of throw their hands up and say, what does that mean? But it's still, you know, under the Vienna Convention on the Law of Treaties, a state, they're obligated to implement their treaties in good faith. And there's also the principle of effectiveness, that if there's a principle or an obligation in a treaty, it must mean something. You have to make sure it's effective. And so that facilitation must mean something. So I think that is a more robust legal response to say you have to give it teeth. And I completely agree with Nina that where you've got cost issues, you know, sort of saying you've got to wait 5 years, I mean, that's not facilitation. So I do think we need to keep arguing for a proper implementation of that, but it's not as easy as saying, well, here's an adjudicatory body that's told us what that means. I mean, just really quickly on the discretion issue, I suppose on one hand you might say, well, you know, for an individual, as long as there's some sort of protection, that's great. But my concern is that it is those sort of humanitarian visas or forms of protection are discretionary. And these are people who are rights holders in international law. So it's actually not appropriate to say, well, you're a rights holder, you're entitled to all these rights, but we're going to set up a discretionary regime that, of course, can be taken away at any time. So I do think it's a fine balance, of course, for advocates, because you don't want to critique that and then lose that form of protection. But I think you've got to remember that these are rights holders in international law.
Okay, thank you. Yeah, I think I'm going to start with the last question that was posed by Ana Paola. Yes, I definitely agree that the approach that many states are taking in relation to these humanitarian permits is kind of weakening the protections on the refugee law. The challenge is that yes, in comparison with other regions in the world, the Latin American countries has been open to accept and to receive more than 3 million of Venezuelans that has been arriving to several countries in the region. And yeah, at some point you don't want to lose that, or you don't want to end up in other kind of scenarios where people can be detained and deported. But definitely many of that people, as has been stated by UNHCR and also by the Inter-American Commission, deserve international protection as refugees under the classic definition or under the expanded definition of the Cartagena Declaration. But also another avenue that I think it will be important to consider and to use in the context of the Americas and hasn't been very used is the form of complementary protection. Like, I wouldn't have so much problems with the special permits that has been granted in some countries of the region if these permits will allow the person protection against refoulement to their countries and will also grant them the same rights as refugees. But the problem is that is not the case, and these permits that has been granted in some countries of the region at some point might end up, and people might end up being returned to their country of origin. In relation to the obstacles faced by Venezuelan nationals in Colombia, one of the challenges is that at some point the relationship between Colombia and Venezuela has been so tense that the two countries broke the consular relationships between them. So the families and their parents couldn't make the consular registration before the consulates in Colombia. So as a consequence of this, the government started to create some measures in order to address this situation. Well, here is a member of the Ministry of Foreign Affairs who can tell you more about the circular that was adopted in Colombia, that was adopted by the Ministry of Foreign Affairs, but also the guidelines that they promote internally in order to order the registration of these children. The problem with the birth registration of these children was that the birth registration established that they didn't have a domicile in Colombia. So at the end of the day, they could have the birth registration, but they didn't have a nationality recognized. So that's what it might be changing now with the measures that are being promoted in Colombia. My concern at this point is that, well, it can be a good response in order to address the situation, but it's not like going to the root of the problem and changing the nationality law in order to make accessible nationality for those born in a territory like many other countries in the region, which would be ideal. And also going back to a point in relation to the question placed by Ana Paula, I think another avenue that we can see useful in order to protect many Venezuelans that at some point might be at risk of deportation might be the use of litigation. But considering the times and the summarity that entails the deportation procedures in the region, my concern is that litigation in these cases might not be as effective as it can be when you are litigating cases relating to the right to health or the right to education. So, yeah, those are my thoughts. Thank you.
So I'm going to take three probably final questions. So this gentleman here, and the lady in the flowery blouse.
Yeah, thank you very much. My question is raised to Michelle. We are aware that there's a Universal Declaration of Human Rights and civil and political conventions rights. It's already indicated the issue of the statelessness and so on. But I think time comes now that we have to have a special international declaration we can deal with the case. It's been a lot of issues being raised, and I can hear now a lot of commitments should be there and over these countries. So what do you think? Isn't now the right time that we should have one special international declaration specifically dealing with the issue of revoking nationality and statelessness? The second question is, some countries, they say that as long as these victims, let me say, within their property, it is something to do with their sovereignty. So they don't allow an international community to be interfere with it. And unfortunately, the same reply we can hear with this international community. When you come to the UNHCR, they said as long as they are within that border of that country, we cannot interfere. If they come out, then we can deal with them. Thank you.
Thank you. My question is also for Michelle. So you identify what I think is a really positive development, which is this fairly recent recognition of denial and deprivation of nationality as persecution. I guess my question is, have you put thought into what we do about the failed stateless asylum seekers that didn't get asylum before we arrived at this understanding? And because, as you know, a lot of these people, right, are stuck in the countries that denied them asylum. They can't get travel documents. At least in the United States, that's a big problem that we're facing. People who are just kind of stuck, and even though we have good law, that law doesn't retroactively apply to those earlier asylum determinations.
So these are stateless.
Stateless failed asylum seekers, yes.
Good morning. I work with the Ministry of Foreign Affairs in Colombia. I want to add about Álvaro Botero's presentation, about your question. We are working at the government in a special measure, administrative measure, to guarantee the nationality, the Colombian nationality, to these children. So since January, we broke the diplomatic relations with Venezuela. So that's why we don't have Venezuelan consulates at Colombia. So the parents, they couldn't register their children. So that's why now we are working on this special procedure, administrative procedure, to register them automatically. The problem is what you said, the root is, we are not working in the root, we still have the problem, but it's just something, an urgent measure to try to guarantee the nationality to them. There are about 20,000 children, but we think there are more because they are the registered, with birth certificate, but without the proof of nationality. But we don't know the other ones, the others that they are not registered. So we are working very hard in this issue because it's a big issue. And also we have a big challenge with refugees, also Venezuelan refugees, that they are stateless. So it's a big problem there. Yeah.
So we're at time, but if we can take 5 minutes to field those two questions.
I just wanted, because she addressed a procedure that is really important to share. The Brazil adopted a statelessness determination procedure in 2017 that sets a very important example, not only for the Americas, but for the world. They integrated, as you referred, a simplified option for naturalization that persons, when they request the statelessness determination procedure, they can opt for naturalization at that same moment. And if they do, then the simplified procedure states that the authority, which is the Ministry of Justice, should solve the statelessness determination procedure in 30 days. And once 2 years of residence have gone by with the statelessness determination declaration, the naturalization will be granted. But since the beginning, the person receives permanent residence in Brazil. If the person does not opt for naturalization when the request is placed to the authority, then they receive an undefined, in terms of time, residence, and they just follow the procedure for statelessness determination. But it is a very good procedure, and it is the shortest in terms of time that we now have in the Americas. Thank you.
Okay, well, thank you for those questions. Starting with the first question about, is it time to implement a new regime? I think my response would be, well, we do have a regime. We have 2 core international treaties in the form of the 54 Convention that's about protecting stateless persons and the 61 Convention about the reduction of statelessness. And I think it's fair to say that neither of those regimes are properly implemented or fully implemented. So I think before we start getting, and I think it's ambitious, and there's nothing wrong with being ambitious, but before we start thinking about new regimes, we need to, I think as a starting point, ensure that the regime that is there is widely ratified and properly implemented. Because as I said before, there's a problem in both regards, both in terms of still not having enough accessions, and then even in those states that have ratified, not actually properly implementing. To give you one example, if all states properly implemented Article 9 of the 61 Convention that prohibits discrimination on the basis of race in nationality laws, then we would probably have a very different situation in terms of statelessness. The point about sovereignty, I'm not quite sure where you're getting at, but I think, you're right that if a person hasn't left their country, they can't be a refugee, so that's not going to be a response, and then the 54 Convention is generally not appropriate to in situ situations. But perhaps one response is to say, the widely ratified human rights instruments, the sort of so-called International Bill of Rights and the other more specialised treaties that are widely ratified, don't mention statelessness in the Convention on the Rights of the Child, ICERD, etc. However, I think there's some really interesting developments where the relevant committees are starting more frequently to sort of, I hate that word mainstreaming, but it's clear that mainstreaming statelessness into the human rights UPR framework and also into their examination of state nationality laws. And that's in fact due to people like ISI. They've done a huge amount of work in the context of the Convention on the Rights of the Child. So that committee is now scrutinising nationality laws in relation to discrimination and the right to nationality for children in a way that it wouldn't have been the case even just a decade ago. So I think that's a way of thinking about state sovereignty. Well, these states have exercised sovereignty by ratifying these international human rights conventions, so let's hold them to what they've done in exercising their sovereignty. So that's a response. To David, I think, I mean, you're right, you can't retrospectively go back and say, oh, you know, we've now got more progressive understandings of these issues. And I think the point too is that even the most progressive implementation or the most progressive and expansive interpretation of refugee law won't accommodate all stateless applicants on the move. And that's why we spend some time in the book, you know, in the conclusion, in saying we absolutely still need statelessness determination procedures. So we're not in any way saying these are mutually exclusive or sort of opposing, you know, sort of methods of protecting stateless people on the move. I mean, interestingly, in most of the countries we looked at, this wasn't well, it was probably a coincidence, but in most of the countries we looked at, the refugee system was the only source of protection, which is probably why there is so much litigation. And that's why, you know, when people failed, they do often end up in detention, or as you say, as we saw so effectively yesterday, in limbo. So our argument is, you still need to we need to expand and keep interpreting refugee law in a progressive way, but supplement that with a proper implementation of the 54 Convention.
And these failed asylum seeker, stateless asylum seeker cases are exactly those kind of catalyst cases we should use to bring, you know, to the public attention the need for stateless determination procedures. Just briefly, a reminder also that UNHCR's mandate on statelessness is global in nature, to the question about sovereignty. And perhaps a question to Nina. Does the database in the European context that compares practice allow you to establish or point to a minimum number of years after which somebody who acquires a status of stateless person should have facilitated, ideally, nationality confirmation procedures? Because this might be useful for what Hervé is talking about in West Africa and also the Latin American context where these are being developed.
So what the index does is it looks at international norms and good practice and compares a country's law policy and to some extent practice against the international norm. So because there isn't a minimum number of years established, and as far as I know, there is, okay? Yes, the European Convention on Nationality, you're right. No?
Sorry. No, but the minimum in Europe, simply because of other European laws that have nothing to do with refugees or stateless people, is 10 years.
Yeah.
But in some countries, it's just 2 years for refugee and stateless person. They have a facilitated pathway in that regard because of the international protection status granted.
Yes.
The problem is the legal residence that is actually used, which is not a problem for refugee because of the status. I mean, those who have a refugee status because it's declaratory, but that could be debatable for stateless person, although I'm sure we could have a similar rezoning.
Yeah, no, so what I was saying is that what the database does is it lists the international norms and good practice, and then it compares each country's practice against that. So what you can find in the database is examples from different countries, as you say, where different standards are applied, where the law and policy establish. So you can see what the law and policy is in different countries, and you can compare that across countries. So you could look at 4 different European countries and see what law and policy they apply. So but it doesn't set new norms, if you like. So the database reports the law, policy and practice and what the international norms are. And it does include the ECN, but we should check with Alison that we've got all the norms that we should in the database. It's a work in progress. So that's what the database does, but it doesn't create new norms, if you like, or necessarily make recommendations on what this should be.
So one final comment from Hervé, and then we'll close.
Thank you very much, Beth. Just to come back on the issue of stateless failed asylum seekers, and stress that indeed we do have a strong parallel between the status of and even the predicament of stateless people and that of refugees. But indeed, they are essentially governed by 2 very distinct conventions, and it is very clear that the object of the Refugee Convention is quite different from the object of the Stateless Conventions, although one can, at times, there are situations in which one can be both stateless and refugees. But there is the purpose of the Statelessness Convention, of the Refugee Convention, is not to ensure protection to stateless people, because there is a specific convention for that. Even though, as Michel very rightfully mentioned, there are instances in which this convention captures also some of the needs of stateless people. And when both status go in parallel, as UNHCR, we also very strongly recommend that we still keep in mind that the refugee status is quite much more protective than the Statelessness Convention. And 2 seconds, if you allow me, Beth, on the issue raised by my colleague Paula on humanitarian visas, just to say that, and again stress something which has been said already, that humanitarian visas as a modality of complementary pathways in nowadays management of migrations is indeed a very, very useful tool. And as UNHCR, we do advocate for more and more of this space. But indeed, this cannot replace the protection status for stateless persons. Neither can it replace the protection status for refugees, because the same question may be asked for refugees. Can humanitarian visas replace refugee status? That is definitely no as a question, but indeed, we should continue to advocate for space for these complementary pathways.
Thank you. Thank you to all of you for some really great questions. Please join me in thanking our panel for their presentation.